The purpose of today's meeting is to conclude a series of engagements examining the direct provision system and the international protection application process. I want at the outset just to remind people to please switch off your mobile phones as they interfere with the recording equipment. We are joined from the Department of Justice and Equality by Ms Una Buckley, Deputy Secretary-General, by Ms Carol Baxter, Assistant Secretary, by Michael Curran, Director-General of the Irish Naturalisation and Immigration Service, and en route, Paul Gunning, Principal Officer, Anti-Human Trafficking Unit. And seated behind them are Ms Louise Sandham, Principal Officer, Mr George Sinclair, Assistant Principal of RIA. And you're all very welcome here this morning. I will shortly invite you to make your opening statement, but first I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him or it identifiable. And members of the Justice and Equality Committee should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. I believe, Ms Buckley, are you to deliver the opening statement?
Yes,
I'd like to invite you to proceed, please.
Thank you very much, Chair and members of the committee. Thank you for inviting the Department to participate in these important hearings on the direct provision system and the international protection process. As members will be aware, under EU and international law, Ireland, like other countries, is obliged to examine the claim of any person who comes here and claims international protection under defined grounds. A person will be granted refugee status if it is shown that they have a well-founded fear of suffering persecution in their home country. Where a person does not meet the criteria under the Geneva Convention to qualify as a refugee, they will be granted subsidiary protection status if they would face a real risk of suffering serious harm if returned to their home country. A person who qualifies for neither refugee nor subsidiary protection status will have other humanitarian reasons to be allowed to stay considered by the Minister and may be granted a discretionary permission to remain in the state. The process of examining such applications is set out in the International Protection Act of 2015, with first instance decisions considered by the International Protection Office and appeals determined by the International Protection Appeals Tribunal, both independent in the exercise of their functions in accordance with the Act. The processes in both offices have been designed with the input of the UNHCR. While an international protection claim is being examined, we offer accommodation and related services to anyone without means. This includes all meals, medical care and utilities. A weekly personal allowance is paid to each person, and the Department of Employment Affairs and Social Protection covers exceptional needs. The Department of Education and Skills provides school places for children resident in the centres, and children also have access to the free preschool scheme, the Early Childhood Care and Education programme. The HSE provides mainstreamed health services to residents. It is a whole-of-government approach to supports and services for applicants. There is no obligation on anyone to accept the offer of accommodation, and there is no restriction on the freedom of movement of applicants throughout the state. Any notion of incarceration of applicants is wholly misleading and risks stigmatising the residents. The pressure our accommodation system currently faces is clear. The Reception and Integration Agency of the Department is accommodating 6,108 people. Those are the figures as of last week, clearly when the statement was prepared, in its 39 accommodation centres, and a further 760 people are in emergency accommodation in hotels and guest houses. The use of emergency accommodation is suboptimal. It does not allow us to provide the full range of services to applicants that the traditional centres provide. However, we must ensure that each person arriving today to claim protection with no advance warning tonight has shelter, food and any urgent medical care required. Coupled with an increase in the number of people applying for protection in recent years is the large number of people with an international protection status or a permission to remain who continue to live in RIA accommodation. We have approximately the same number of people in this scenario as we have applicants housed in emergency accommodation. People with status or permission to remain have the same access to mainstream housing supports and services as nationals. And we are working intensively with organisations like the Peter McVerry Trust, DePaul and the Jesuit Refugee Service to assist these people to transition to mainstream housing services. But as members will probably realise, that is extremely challenging in the current housing environment. The committee heard from Mr Justice Brian McMahon of the improvements that have been made to the system in recent years. Significant improvements have been made to the system to deliver real improvements for living standards for residents in living conditions and standards. Chief among these is the introduction of independent living. And I understand that most members of the committee visited the Mosney Accommodation Centre last Friday, where they will have seen how independent living works firsthand, including the food hall, where residents can obtain food and toiletries through a cashless, points-based system. Over half of all residents now have access to cooking facilities, and our aim is to have all residents in commercial centres benefiting from independent living by the middle of next year. This will be achieved through our ongoing regional tendering process for the provision of accommodation. Successful bidders will also have to provide dedicated living spaces for families and teenagers and greater facilities for recreation. Standards developed by an advisory group have recently been finalised and approved by the Minister and will be applied in all centres. Access to the labour market has also provided an important integration opportunity for eligible applicants. To date, the Minister has granted 2,633 labour market access permissions, including over 1,900 to direct provision residents. Residents also have access to the services of the Ombudsman and the Ombudsman for Children. Importantly, each centre also now has a Friends of the Centre group, and this initiative brings together residents and local community and voluntary groups to increase integration opportunities and to provide support for residents by local communities. The Department is now engaged in its own review of the direct provision system. I chair a high-level interdepartmental group to examine the current system and to report to the Minister. As part of this work, we are identifying any gaps in service provision, areas where we can strengthen existing service provision and supports, and may propose alternative options for the provisions of services to applicants in the short and in the medium terms. The work of the committee will be an important consideration for the interdepartmental group. And as Minister Stanton has said previously, we would welcome proposals and tender responses from individual NGOs or groups of NGOs who want to work with us to improve the system. Indeed, we are already working with some NGOs to see how they can play a more active role in supporting residents. The system has provided a safety net for more than 60,000 individuals and families since its inception 20 years ago, but there is, of course, room for improvement. These committee hearings are very timely and they coincide with the work already underway in the department. And we've been following the hearings to date with very great interest. We have listened carefully to the testimony of witnesses. We share many of the views expressed to you. The system of deciding on applications must continue to get faster, and the improvements to living standards must continue to be implemented. Where we may differ is on how we get there and how quickly the protection determination process can be made, taking into account that it is a legal process which requires full consideration of all aspects of each individual case. We are open to engagement with all stakeholders to provide a system that is responsive to the needs of applicants, that treats applicants with dignity and respect, and that continues to meet our international and humanitarian obligations to people seeking international protection from the state. And Chair, my colleagues and I will be happy to answer any questions that you or the members may have.
Thank you, Ms. Buckley. Thank you. So we have a number of members indicating, and the first of those is Senator Frances Black, please.
Thank you very much, Caoimhghín. Thank you all. I want to thank Ms Buckley and the Department for coming in today, and I take on board all the information you've given us, but I have to say that this review has been extremely difficult. I'm sure you can be aware that, you know, it's been for us here, it's been devastating to hear some of the direct testimonies from people living in the system. And in your statement, though, you say that while changes have been made, there's still room for improvement. And I understand that the department is taking steps, but to me, I feel it's a huge understatement. And I think this committee's role is to highlight as clearly and as fairly as possible that many places we see where the system is falling short of what's expected in terms of human rights and basic dignity, and to propose changes. That's really what our role is, as you know. And some of these changes relate to the system as a whole and are political decisions that must be made at government level. So I want to focus instead on specific questions that's related to the operation of our asylum system and the department's responsibilities. So, firstly, the issue of waiting times and delays. After the passage of the International Protection Act, a committee was made for a 9-month limit on a first instance decision. So currently, the median wait time is 15 months and the average is likely much longer. So why is the target being missed, and are more resources and staff needed to meet it? Now, I have a good few questions, so I hope, because I'm under pressure for time, so I want to try and get as many as I can in. So anyway, why is this target being missed, and are more resources and staff needed to meet it? And does the department have a timeline for when it expects to get the figure down to 9 months? Similarly, there's often a long delay between people receiving a positive decision and then getting the final letter from the Minister. So what's the reason for this delay, and what's happening in that period? And that's the first piece I just want to focus on. There's 4 different areas, so I know I'm throwing everything at you. And then the second one is standards. And, you know, this is critically important and has repeatedly come up during the hearings, and the difference in the quality of standards and facilities. It's astonishingly and unbelievable, and it urgently needs to be addressed in the short term. There's no doubt about it. So, as I understand it, the standards have been agreed and they'll be published soon. So, can you give us an overview of some of the areas that will be covered and how they differ from current practice? And then, secondly, this is crucial, what kind of oversight mechanism will be put in place? Any standards won't be worth having unless they're closely monitored by an independent body with real teeth and random inspection, and I think this is absolutely vital. And it's been suggested during the hearings that the remit of HICWA could be extended to cover this. So can you tell us how oversight of the standards will work, and if there will be reporting on whether the standards are met? Thirdly, the EU Reception Conditions Directive includes the need for an ongoing vulnerability assessment, and I've read replies to PQs on this issue, but it seems that what's being described is actually the basic medical screening carried out in Bailskin. That is different to a proper vulnerability assessment because it doesn't pick up issues of mental health. This is an area I'm specifically interested in. Trauma and sexual abuse. And can you elaborate on the screening process and how the legal requirements for an ongoing vulnerability assessment is met? And finally, this is an area that I've just started to explore now. It's on the issue of profit. And I know the decision to operate our asylum system on a for-profit basis is a political one. But looking through some of the materials on the contracts yesterday, I was quite shocked, and I'd like to get the department's perspective. So let me give you an example. Bridgestock is a company that runs 2 direct provision centres, Globe House in Sligo and the Old Convent in Ballyhaunis, County Mayo. The state pays them around $6 million per year to run these centres, and since 2000 they've almost made $100 million. In 2011, however, the company became unlimited and a majority of its shares were transferred to the British Virgin Islands. This means that detailed accounts are not published and the company is shielded from public scrutiny. So do you think that this setup, whereby a private company with majority control exercised from the British Virgin Islands with no public transparency as to their costs, their profits, is conducive to a safe and respectful asylum system? And also it's been said that the average amount paid to each company is €35 per asylum seeker per night. In Bridgestock's case, that came to roughly $6 million last year. So do you, the department, know exactly what the profit margin is for the companies? running these centres, how much of that €35 of public money is spent assisting asylum seekers, and how much goes to the shareholders? So I'll leave you to answer as many of those questions as you possibly.
Quite a lot to start with, for sure.
Unfortunately, I have to leave.
I'll open it up to Ms Buckley first of all, but can I indicate to the panel that if you wish to add to any particular response that she gives, you're very welcome. If you just indicate to the Chair, and I'll invite you then. Is that okay? So, Ms Buckley, please. That's
fine. And indeed, I might ask one of my colleagues to come in on a more detailed answer, because obviously I might know the generalities, but not the detail. With regard to the waiting times, the goal of the Department is to meet a medium time for first decision from the IPO in 9 months by the end of this year. We are, however, a way off that at the moment, and that goal we may miss, I should say. Part of the challenge to us has been, while we have increased staffing in the IPO of civil servants by 20%, and we've doubled the number of legal advisors who do the initial interviews and so forth in the last 2 years, it is challenging actually for the civil service to recruit people into what is, as you know, an extremely tight labour market. So we struggle to recruit the necessary staff in a timely fashion, and that is a problem that's not unique to the Immigration Service or indeed the Department of Justice. It is an issue in Dublin where you're trying to recruit civil servants. However, I should say we have increased the staffing there by 20% in 2 years. We have doubled the number of legal advisors who do those initial interviews. So we are in a place to try and we have reduced the overall hearing times. A second issue that has arisen is that when the 2015 Act came into force, there was at that stage some thousands of existing applications that were in the system at the time, and they were reset to zero and started again through the process. So there was a challenge of dealing with that bulge of overhang of applications that were there at the time, and because of legal restrictions and legal requirements, and indeed the requirements of the UNHCR, they had to be dealt with in a timely fashion, in order, in effect. So, unlike other organisations that I've managed in the past, where we were able to do the new applications and the existing applications in 2 streams, this had to be done in a kind of a consecutive order. So that did lead to a very large delay, in effect built in from the get-go. What I would say is the team in the IPO are getting on top of that, and we are moving towards a situation where applications, which are now of course coming in under the new Act in first instance, are being dealt with in a more timely fashion. You also mentioned delays between the decision being given by the IPO or IPAT and the letter issuing from the Minister. And certainly there has been an issue about an extended delay that was due to checks being conducted, final checks involving some of these states, where a final run-through was made to make sure that the person had, for example, was there any issue of a criminal record or so on and so forth. But as my colleague Michael will be able to tell you, we have now introduced a new policy of issuing those letters in a much more timely fashion, and we should start to see that come through very shortly. Michael, you might want to come in on that.
Yes, Chair, thank you. Just to add to that, we currently have about 330 of those cases on hand. We have assigned additional resources to clear them in the next 4 weeks, and at the end of that process we expect the new decisions coming through to issue within about 10 working days. So we have changed the process by running some of this in parallel, so that there is no delay at the end of the recommendation coming from the International Protection Office or the International Protection Appeals Tribunal for the actual decision letter to issue.
So the second question you asked was around standards. As I mentioned, the standards have been drawn up and were recently approved by the Minister. We are currently working with the Minister's office on establishing an oversight committee, and there, as you know, an oversight mechanism, an inspection mechanism is part of the structures established for that. I should say that we haven't yet determined what that inspection mechanism would be. But what I can say right now is that there are independent inspections of our direct provision centres to the standards that currently apply, and those are unannounced. RIA itself makes 2 unannounced inspections every year, and a body contracted by RIA makes a further unannounced inspection every year to make sure that the standards that currently apply are being met. We certainly will be looking at the introduction of an independent inspection mechanism, and it will be subject to the oversight of a committee that will be there to ensure that the department manages and maintains the system to those new standards. As to the detail of the standards, can I hand you over to my colleague, Ms Baxter, who will talk you through those.
The standards are an example of the collaboration that RIA has had with the NGO sector. The NGOs such as the Jesuit Refugee Service, the Children's Rights Alliance were integrally involved in the standards development process, and the standards were themselves developed, facilitated by an independent facilitator. So it's a very good example of collaboration. So it obviously covers accommodation, food, living conditions. Just to give one example of where it's going to be a step change, it's in the area of training. It will require ongoing training of centre staff and management in relation to person-centred approaches to the delivery of services, but also to have training in terms of interculturalism, awareness of trauma, of mental health issues, of whether a person has experienced sexual or domestic violence. So for us, we feel that it represents in that one alone a step change in terms of the capacity of the centre managers and staff in terms of engaging with centre residents.
The third aspect you mentioned is vulnerability assessments, and obviously it is a legal requirement of the directive that a vulnerability assessment is carried out. Now, I mentioned that putting people into emergency accommodation isn't the optimal solution. It's not something that we're keen on. And part of the reason for that is that it becomes harder for us to offer the same kind of assessments as to vulnerabilities as is available in the standard direct provision centres. So you are correct that we also had a difficulty in Balseskin in that we have had a couple of cases of chicken pox. It's a very human situation, but the protocol with the HSE is that we have to not put any children or women of childbearing age into that centre while a period of elapses since the case of chickenpox was detected for obvious medical reasons. So it has been very challenging for us to try and make sure that people arriving into the country, and I should say that the numbers are going up year on year. It's gone up about 30% a year every year for the last little while, that they achieve that. So how we are managing that is that because the chickenpox protocol has elapsed and we're able to put people through Balseskin again, we are now giving the necessary vulnerability assessments or health screening, certainly through Balseskin for arriving visitors. We also have the HSE also has an arrangement in place with a company called Safety Net, and they attend to areas like the emergency accommodation centres to ensure that certainly medical and other screening can be done there. You're quite correct as well in saying that vulnerability assessments extend beyond medical screening. Or indeed, they need to detect things like mental health conditions that may not be apparent on the first instance. So we do believe that it's a necessity that those things get picked up as time goes by, and that every instance where a person interfaces with, say, with RIA or with the IPO or whatever, that there may be another opportunity for those sort of screening and assessments to occur. And it is certainly, we believe, that, and this is our advice to the GPs and so forth that we interface with, that at any point where they detect part of that's something that needs to be fed back within, of course, the confidentiality limits that arise for anybody's own medical conditions, that where those are known to RIA, we can certainly address them. So it is something that we continue to have to work towards making sure that we meet the legal requirements. We believe we are meeting the basic legal requirements at the moment, but it's something certainly we need to work towards. And particularly for the situation where we have so many people in emergency centres, that it's really not ideal, that it's much better for people to be in the direct provision centres, despite the ongoing public discourse around them. Finally, as to the issue of the use of private companies, as you pointed out, it's a policy decision as to the use of commercial companies, both in the running of centres on state-owned property and that we contract with private companies, and that situation will continue. I suppose it's worth saying that obviously we require everybody that we interact with to comply with the law of the land. They have to have a tax clearance cert, for example, so that's a requirement. And obviously the obligation on us is to ensure value for money as well in the delivery of this service, in what is a demand-led service where there's a very significant challenge around the budget for the service, particularly this year. But as you quite rightly pointed out, the question as to the use of commercial companies is a policy decision and not one I can comment into. Thank you, Senator.
Senator, is there anything further?
Apologies that I have to leave a little bit early, but thank you for your
Thank you, Senator Black. I'll now move to Senator Martin Conway, please.
And you're very welcome to this committee. And this committee and the previous Justice Committee have done quite an amount of work in this whole area, and I've taken a particular interest in this area. But what really, I suppose, concerns me is that I haven't really seen a huge amount of improvement. You know, the talk is good, the interagency engagement and the interagency linkages all sounds good, but time and time again, the examples on the ground do not stand up to the presentation that comes from the department or from RIA. I see situations where in some centres children are accepted into the local national school, but yet the supports and services are limited and very limited in terms of what's made available. I've seen other situations where the children from direct provision centres aren't accepted into the local primary schools. I think the protocol should be that the local primary schools should be obliged to take the children, and they should not be in a position to refuse to take the children from direct provision centres. But for today's engagement, I suppose I want to focus on emergency accommodation. And I have a few questions, and I'm going to start with a very simple one. Have ye, or has RIA, ever been in a situation where they have been unable to find an emergency bed for somebody who is presented seeking assistance from this country? Has there been any example of where somebody has ended up being homeless because accommodation cannot or has not been found in the recent past?
Senator, just specifically to that last question, in the autumn of last year, before we moved into moving people into emergency accommodation, some people were turned away because there was no room within the direct provision system. That's why we moved to the emergency accommodation model. We now have people in, I think it's 25 locations in hotel beds, essentially. So we are now using emergency accommodation because we had to turn people away at one stage.
So essentially then the emergency accommodation structure that's in place now is just going back to last September when people presented and you weren't able to accommodate them?
Correct, yes.
And where did those people sleep when you turned them away?
It happened over 2 weekends, Senator, and the minute we got further accommodation, we immediately went back to people and actually indicated to them that during the subsequent weeks that we had accommodation for them. So where we had details of people, we were able to offer them accommodation, but obviously people where we didn't have their details had to go to the homelessness services.
So essentially what happened was the Department of Justice and RIA were unable to accommodate those people, and they were turned away essentially by the Department of Justice and RIA, and then they had to access services like the Peter McVerry Trust or people like that.
It happened over 2 weekends last autumn, Senator, and since then we have managed to keep ahead of demand for beds for the night by the use of emergency accommodation.
I accept that, but did you not envisage that that situation was going to present itself? And was it not irresponsible to allow that situation to have escalated to the level that it did last September?
And we heard some suggestions made by that in the previous committee hearings. I think it's worth pointing out that it is not possible for us to estimate how many people will present applying for international protection any one day. For example, there was one day at the beginning of this year where 132 people presented themselves looking for international protection in a single day. The other aspect of things that are changing is that the flow of people into the country is changing for the countries they are coming from, and that is affected by developments outside of Ireland. So, for example, a very large proportion of people now applying for international protection are coming from Albania and Georgia. Albania and Georgia are regarded as safe countries by Ireland. Very large numbers of people are seeking international protection in those countries. We believe that is due to a change in visa arrangements in the Schengen area, which is outside the control of Ireland. But those changes could not have been anticipated by the Department of Justice, say, at the beginning of last year.
Okay.
I should also say, Senator, just to be clear, that we are working very hard to try and increase our stock of accommodation, and we have added substantial numbers of beds in the last 2 years and continue to seek to do so this year to try and keep ahead of demand, as well as managing the throughput of people so that people who have permission to remain in the country leave our accommodation or are moved into mainstream housing.
And all of the system isn't wrong. There's very, very good elements to the system, and we saw examples of that last Friday where we went on a field trip down the country. So what I want to do now is just move it on. So now we are in a situation where there's an emergency accommodation structure in place since last September. What are the financial arrangements between RIA and the providers of these emergency accommodation beds? As opposed to the direct provision beds, the actual emergency accommodation beds. What protocols have you in place to, I suppose, ensure basic standards in these emergency accommodation beds? I suppose what I'm trying to do is just get an understanding of, what the arrangements are with the emergency accommodation providers that's different to the arrangements for the direct provision centres, which are more established.
It's a very valid question, and as I've made clear from the get-go, from the start of our presentation here, emergency accommodation is not at the same standard as the direct provision centres. We cannot impose, for example, our standards that we can require of the direct provision providers. We can't impose them on hotels and guest houses, which is where emergency accommodation effectively is being provided. So what we are trying to do is make sure that people move out of the emergency accommodation, particularly families, as quickly as possible, so that, for example, we don't have a situation where children are left in a hotel situation before being moved into a direct provision centre where they can be registered for schooling. I don't know whether Carol, you want to...
Well, I'll give you one example of what's happened in your emergency accommodation. I'm aware of one example last January, where there was residents in, and I've brought this to the attention of the Minister. I spoke to the Minister directly about this, so the Department aren't unaware of it. I'm aware of a situation where people were in emergency accommodation. They were bused on a journey 6 or 7 hours to another part of this country in order to facilitate a wedding in a venue that has been used for emergency accommodation. When the wedding was done and dusted, they were shipped back. They were treated, in my view, in an appalling way. And no department, or no provider of emergency accommodation either for that matter, can stand over the way those people were treated. And it wasn't an isolated incident. It happened more than once. Now, I've got an assurance from the Minister after I spoke to him and informed him of that, that it would never happen again. And the question I have for you is, are you aware of that incident, or those incidents rather? And can you give this committee an assurance that such incidents haven't happened in the last 2 or 3 months?
We certainly are aware of that incident. after it happened and we were made aware of it, we spoke to the accommodation provider in that case and received assurances from him that it would not occur again. And to the best of our knowledge, there has been no similar incident in the last few months.
Well, that's good news. It should never have happened. I also understand that your engagement in terms of getting beds as part of emergency accommodation, that you're actually going through third parties, that you're effectively dealing with what I would describe as entrepreneurs who block book bedrooms, and you negotiate with those people then. So I think you have a job of work to do in terms of streamlining and streamlining your protocols for emergency accommodation and ensuring that, that they're transparent and appropriate and respectful and done properly, because ultimately we want to ensure that the quality of the accommodation of people who come to this country seeking our assistance is up to a standard, and also that taxpayers' money is used in the most efficient way. And I know that, just going back finally at Clare, because I have to go as well, it's often said that, where would somebody get full board and bed for €35 a night? That is good value. But what I say in return to that is, when you have a facility that is 100% occupied, 7 days a week, every week of the year, it's easy to achieve efficiencies in €35. And certainly we have a duty to significantly and fundamentally upgrade all of these direct provision centres. People like us in this committee shouldn't be hearing stories from residents. It should just not happen. And until such time as it does not happen, unfortunately, you're going to be before this committee and other committees explaining why it does happen.
Well, just to come back on that, Senator, we would like to get out of the business of emergency accommodation entirely. For that, we need to open more direct provision centres. We're working our way through a procurement process to achieve that, and obviously we'd welcome the support of members of the committee for the opening of new centres where we can offer facilities to the standards that we aim to achieve.
Okay.
Thank you. Thank you, Senator. Deputy Jack Chambers, please.
Thanks, Chair, and I'd like to thank the officials for appearing before us. I just followed on from a question from Senator Conway there about emergency accommodation. What's the average time spent at present in emergency accommodation, and what's the maximum time at present for people in direct or people who are in emergency accommodation?
I wouldn't have a figure for the average time spent, and obviously we are trying to move people through the system as quickly as possible into a direct provision centre. There are some individuals who have been in emergency accommodation for upwards of 9 months, which is very unfortunate. But as I say, part of our issue is that we have roughly 730 people who have the right to remain, who are living on in our direct provision centres. And who we are now working very intensively with a number of NGOs and with those residents and with the CCMA to try and move them into mainstream housing. In effect, if we could resolve our problem of our overstayers, we wouldn't need emergency accommodation. So it's an important part of our structures that we are to move people out of direct provision into mainstream accommodation, so that we can cease our use as best we can of emergency accommodation.
So you mentioned 9 months. Would anyone have spent more than that?
No, we've only been using emergency accommodation since September of last year.
So 9 months. And so do you accept that obviously you've got one set of standards for direct provision centres and then a less governance control over emergency accommodation?
We do, absolutely, yes.
Yeah. So what have you done, because you have an issue now with with increasing numbers within emergency accommodation for increasing periods of time? What governance arrangements are you developing to ensure that you develop standards around emergency accommodation so that we don't have the scenario that Martin mentioned about people being shipped like cattle around the country to facilitate the private provider? I think that's extremely important and something that the department has to square off properly, so that there are protocols around standards. Because, in your statement you mentioned, the medical care. You mentioned how, the accommodation and governance I think we need to hear more about what you're doing in the whole emergency accommodation space.
So, first of all, can I say, Deputy, just the phrase "ship like cattle" is obviously very pejorative, because we're talking about human beings here, and it was one instance, and when we became aware of it, and obviously the senators mentioned that, we did address it.
Correction.
I think the fact it happened at all,
yeah.
The fact it happened at all was unacceptable.
The fact that human beings who are vulnerable anyway.
The fact that it happened at all was unacceptable, and we addressed it with the provider.
In that scenario, cannot be defended, or
and it isn't being defended by me, and was addressed with the housing provider. I might just to say to you.
Sorry, Chair. How was it addressed with the housing provider?
With all respect, Deputy Chambers continues
I just think
the
point remains that should have been a trigger to ensure that you develop proper protocols and governance around emergency accommodation, and because clearly, as you mentioned, people who've come here have been left at the behest of people who've shown a total disregard and disrespect for their basic physiological needs and human rights. For anyone to be thrown around like that, I think is a terrible disgrace. And as Martin mentioned, it's not only one incident. There are other incidents that people have expressed concerns about. And what I want to know is, what are we doing to formalise standards and governance and protocols around emergency accommodation providers?
So, again, I repeat, we want to get out of the business of putting people into emergency accommodation to give them a roof over their heads when they present themselves looking for international protection. But in the meantime, as we have moved into the situation where more people are going into emergency accommodation, we are working to try and formalise some of the important standards that people require. So the key ones are around child protection, around educational needs being met, and around health screening, as well as having a roof over their head, and as well as treating people with dignity and respect. So I might just ask my colleague just to go into that in more detail.
And Deputy, obviously, we had always intended that the use of emergency accommodation would be a very short-term thing, and when we actually moved into using emergency accommodation, you will remember we actually had contracted a series of centres which such as Moville and Ruski, which we weren't subsequently able to use because of the arson attacks. So at the time that we started to use emergency accommodation, we understood that it was going to be very short-term in nature. Now that we realise that it is going to be somewhat longer term, although it is our objective, if we can, to move out of emergency accommodation by the end of this year, we have worked interdepartmentally to address the situations. So we are actually working with the HSE, the Department of Education and our own staff in terms of ensuring that standards are met within the emergency accommodation hotels being used. But in addition to that, we recognise that we want a more active presence in those centres. So we are actually contracting NGOs at the moment to act as if you like, as an opportunity for residents to highlight issues that are arising for them. So we intend that they will be a presence on the ground in addition to our own staff in those emergency centres.
Has everyone in emergency accommodation been assessed by a general practitioner? Had a health screening on their
yes, the HSE contract with a company called SafetyNet, and SafetyNet provide health screening into the emergency accommodation centres.
Okay, and I want to ask, in terms of their educational needs, how is their right to education being vindicated for children within emergency accommodation? In
general, we believe it best that we try and move children who are within the span where they require the school places, that we try to move them into the direct provision centres as quickly as possible, so that they have a more long-term situation where they can be placed into schools. In the initial phases where we were having to put families into emergency accommodation, some ad hoc arrangements were made for schooling. We're now working with the Department of Education to more formalise the offer of educational needs for people in those centres. But as I say, it actually is not ideal, and we would much prefer to try and move as many families as possible into the direct provision centres so that the established arrangements around schooling can be applied to them.
And what would that ad hoc arrangement involve between, for say, a child, a 7-year-old in emergency accommodation? Can you detail what that ad hoc arrangement would be?
So we understand that some parents put their children into schools directly, and this was before we had established sort of better ideas around the need to apply those, to ensure that parents were advised of what was available in terms of school places in the local centres. So we have moved from a situation where there was not good information provided to parents to a situation where better information is being provided to parents in those circumstances.
And going to, in terms of direct provision centres, are you satisfied that every child within direct provision centres has access to education?
Yes, that is of the educational age.
Yes.
Yes.
Okay. And has there been any circumstance where that isn't the case?
Not that we're aware. There in the Oireachtas, would it be worth mentioning?
We obviously have schooling for people, for children of school-going age in our Oireachtas centres. That's directly in the centres, because the residents there are typically there for a shorter period. But in terms of residents of direct provision centres, our understanding is that all children have access to school places, and we actually have a co-located officer within RIA from the Department of Education and Skills, and she engages with all centres to ensure that children are given school places.
And do you audit that? Do you, like you say, you have no awareness, but do you actually audit that within the direct provision centres? Or is it just if it's brought to your attention? How do you assess that?
We engage with all the centre managers to make sure that they make us aware of any children of school-going age in those centres, and we immediately then bring that to the attention of the education-related person in RIA.
Do you not think it would be better to have a separate, independent oversight of that important right within our centres, and similarly around healthcare and HSE interventions, like you mentioned that there are wraparound services? Are you satisfied with the level of healthcare provided within these centres?
We work very closely with our colleagues in the other public services to try and ensure that those services are provided as best we can. Now, people in the international protection process have the same rights to healthcare as Irish citizens, so I suppose it's a broader question as to whether there is sufficient healthcare services generally, particularly around mental health, for example. But we work very closely with them, and we work extremely closely with the Department of Education. As I say, there is a co-located official who tries to ensure that the goal is to meet our legal obligations around the education of children. And in some instances, I should say that there's been a very positive outcome from having children come through into a direct provision centre, in the sense that it can be the trigger for the allocation of additional resources into local schools, additional teachers or additional support services, because of the children being present that are as part of the international protection process.
Just in terms of direct provision centres generally, how many have you had to close based on serious difficulties around governance, management or oversight?
I don't have data for all of the time, but certainly we did have to close one centre in 2016 for fire safety reasons.
Okay, for fire safety reasons. And have you formalised any concerns around other issues within direct provision centres that might necessitate a future closure?
I should say that we are currently engaged in a procurement process to bring all our direct provision centres up to the new standards that will apply from the 1st of January 2021. And it would appear likely to us that a number of the existing centres will not meet the standards and will have to close.
And what are the issues?
independent living would be a primary one. In other words, that they will be unable to provide independent cooking facilities would be a good example. They just won't be able to meet the standards around space and around facilities.
And just around, I suppose, what I'm trying to get at here is the governance. Like, do you feel as a department, because of the pressure for space and places and general demand that you've mentioned earlier on, does that in any way compromise your standards around accommodation, around, say, school places, around healthcare, and how do you deal with that difficulty in terms of governance and oversight?
The use of emergency accommodation is suboptimal. It's worse than direct provision. For all that there is so much, naysaying about direct provision, it allows us to provide public services in a more coordinated way into a group of people in a group setting, and people who tend to have very high levels of needs because of some of the circumstances they've come from. So the use of emergency accommodation is not where we want to be, and we need to move away from that. Now, as it has appeared that the use of emergency accommodation has become a more regular feature of the system, we're moving to improve our governance arrangements around that. But I just want to say that in the circumstances where we're under an obligation to provide a bed, like a roof over the head of every person who presents, and we have no control over the demand for that roof, that we struggle very much to keep abreast of the demand for bed places. And that's just something that we have to work extremely hard every day to keep on top of. We are happy that we are moving towards a better arrangement, better standards for direct provision more generally. But for that to happen, that we do need to increase the numbers of beds available to us in the system, and we do need to move people with status out of our direct provision centres and into mainstream accommodation.
Thanks.
Thank you, Deputy Chambers. Senator Niall Ó Donnghaile, please.
Thanks, Chair, and thanks to the officials for their presentation so far. A number of colleagues have asked questions that I was going to ask already, so I won't engage in repetition. I do want to hone in on this issue identified by Jack and Martin in relation to the movement of people who are in emergency accommodation. I would like to know, Ms Buckley, just in terms of when you say on one hand this was addressed with the provider, but then you have also said you can't impose standards on emergency accommodation. That's a screaming admission to me. That's a screaming contradiction. So I suppose my fundamental question is, while it's all well and good as far as we know it hasn't happened since, can it happen again?
It's two different things, Senator. What we cannot do is impose direct provision standards on private hotel owners. But what we can say in circumstances where there's a very clear breach of what we anticipate as being the requirements of somebody who's providing this emergency accommodation, we can say we'll withdraw from using that hotel or that facility. So we believe that it is certainly possible for them to meet our contractual requirements, but what we cannot do is say to them, you have to meet all the standards that come with being a direct provision centre. And that's the difference.
Would you deem that as a breach, people being shipped away for a weekend to facilitate?
Oh, and we addressed it with the provider.
Has that provider been closed and people relocated?
What we said was, if that happened again, we would close. And
how would you know if it happened again?
Because just as we found out now, typically if residents are being moved, they would bring it to the attention of RIA. We would know if people have been moved.
Well, with the greatest respect, I understand what you're saying, and I understand the dynamics at play here. But I don't think it's good enough to simply rely on that. We're talking about people here who are facing extreme marginalisation, people who are facing massive issues, PTSD, all kinds of things, and we're just going to hoping that in a few weeks they're going to tell us via a third party that they have been shipped in a bus a couple of 100 miles down the road to God knows where, in the precarious situation they're already facing. I just think I mean, I acknowledge that you can see the emergency accommodation situation is not acceptable and not fit for purpose, but this is a scenario that we're hearing and that is imminent, and that there seems to be there are no measures in place that can proactively and preemptively prevent this kind of situation stopping again. And I have to say I'm extremely concerned by the fact that this has been identified already in terms of an existing provider, and that person and that facility is still operating, and there's people still existing, because I wouldn't quite call it living in that accommodation. So I want to make that point. Ms Buckley, earlier on you identified rightly the issue of value for money. I'm wondering, is there a definition of what value for money is, if that's written down anywhere, if there is a terms of reference in terms of that statement, ensuring value for money? What does the department constitute as value for money for a person living either in emergency accommodation or direct provision?
We don't have a written statement. As civil servants, we are required to achieve value for money in the use of taxpayers' money. And I think, as one of the other members of the committee pointed out, that means that we have been achieving that per person, per head cost of somewhere in the mid-30s. That cost is going up, because as we go through the existing procurement process, and without revealing any commercial secrets, in order to meet the higher standards, there will be a higher level of cost per person per night for people in the new model of direct provision centre. But that's the right thing to do, because those are the standards that we must meet.
But currently it's around €30 odd.
So it's in the mid-30s.
And is that in both?
For the centres that were contracted under the older model.
And is that in direct provision and in emergency accommodation?
No, in the emergency accommodation we're paying rack rents. So we are paying the nightly cost of beds in those hotels. Okay, so that is a huge cost pressure within the budget for direct provision.
That's kind of mad, isn't it?
It's certainly a position we do not want to find ourselves in, and that is why we are working extremely hard to move people with the right to remain out of our direct provision centres, because if they were not in the direct provision centres, we would be able to accommodate the people who are in emergency provision. Do
we have the figure for the amount of people in emergency accommodation currently?
It's about 710, 715, but it changes on a nightly basis.
Okay. Final question, Chair. I'm just wondering, in terms of the statement about the upcoming standards in terms of newly acquired direct provision centres, I'm wondering if you can put, even if it's not a specific figure, if it's more general, I'll accept that, around current direct provision providers who aren't meeting those newly defined standards around independent living, cooking facilities, maybe other issues. Do you know how many of them you'll have to close based on the new standards to which you referred? How many people can expect to be relocated into those new centres, and how long, I suppose, will they have to wait until they can relocate into those higher, or what's deemed to be higher standards within direct provision? About
10 or 11 centres at the moment meet the independent living standard. So about 2,500 people have independent living standards. That's the arrangements that the members will have seen in Mosney. About a further 1,400 people have access to independent cooking facilities and can provide their own food. They don't have the on-site shop. We are aiming by the middle of next year to have completed the procurement process and achieved the new standards across the entire complex of direct provision centres, both the existing ones and new ones that may come on stream through the procurement process. And obviously we do need additional direct provision centres to come on stream to provide us with additional beds. I don't have a figure in my head about what centres that we currently have may not make the standards. And I should say that it isn't the case that it is necessarily because they will meet the standards and not meet the standards that centres open and close. So, for example, we have a Hatch Hall which is due to close in Dublin City Centre. There's no suggestion that that's closing because it won't meet the standards. That's closing because of a commercial decision. It's being redeveloped into a hotel.
Thank you, Chair.
Thank you, Senator. The next I have is Deputy Donnacha O'Leary, to be followed by Deputy Jim O'Callaghan, please.
Okay, I suppose, first of all, look, just to thank the officials for coming in. This is a very important part of our engagement. It's been, I suppose, over the last couple of weeks, a really valuable engagement. And Look, I mean, it's my view, and I've stated it, I'm sure you've been following the hearings. I think direct provision, as said before, and I say it again, I think it's lost the confidence of, certainly, the residents, and I think it's lost the confidence of the Irish people. And what our responsibility as a committee now is to formulate a proposal in our report that provides a comprehensive, detailed alternative. While I acknowledge that there has been improvements, I think that there are still significant shortfalls in direct provision itself. But this issue of emergency accommodation, I want to deal with that, I suppose, just first of all, because I suppose I'm conscious of the fact that our hearings are on the system as a whole, direct provision, international protection. But like, I suppose I'm just beginning through this hearing and the last hearing to get my head around the scale of this. So this is a situation that has begun prior to last September. Are you saying that there was no one in emergency accommodation through direct provision system or through international protection? That's already escalated to 687 in mid-May, and according to you today, even since mid-May, it's arisen to 760. So that's an addition of 70 or 80 since then. Like, I mean, is it your view that that's going to continue to escalate? Could we be back here in a few months talking about 900, 1,000 in emergency accommodation? Is that possible at that rate of increase in September?
If we aren't able to achieve opening new direct provision centres, we will be seeing more people go into emergency accommodation because we have no other way of providing them with a roof over their head. So as to the numbers, we cannot say, because that's dependent on demand. That's literally dependent on how many people we come into the country seeking asylum or international protection, and how many people we're able to move into mainstream housing out of our existing direct provision facilities. And we spend I have staff working for me, working very hard every day to try and achieve that. But it's an entirely demand-led scheme, and if we are to meet the basic human requirement of putting a roof over people's heads, we will continue to, at the present, we will continue to have to put people into direct provision. Now, our goal is to add a net 1,200 beds to the direct provision system by the end of the year. And we are still hopeful that we will achieve that, but my colleague has already mentioned 2 centres that we were seeking to open that were the subject of attacks. That didn't help, and it certainly is extremely challenging in the current accommodation environment to manage the process.
And look, I mean, I suppose I appreciate that there is obviously an obligation first and foremost to provide a bed, but like, I mean, as I say, that rate of increase is almost exponential, and it is, I think, terrifying to think that, like, I mean, if that rate of increase continues, like, it doesn't seem to me to be beyond the possibilities of 800, 900. I don't know. I'm aware, am I right in saying that the department is, as well as obviously seeking to provide additional direct provision places, is advertising for emergency accommodation as well?
We are,
at this
yes.
point in time. That's correct. You stated there that this arose as a situation over 2 weekends in August, I think, of last year, that this was the first time that people had been refused a bed. Am I right in saying that there was a case taken X and Y versus the department relating to an application in September of last year for accommodation?
It predates my presence in the department, so I'll have to pass the question to my colleague.
Yes, there was obviously a case taken, but before, we have, there are 2 categories. There are people who seek readmission into direct provision having left direct provision, so there can be cases taken in terms of readmission, but we, up to September of last year, we hadn't actually turned an initial applicant away, and that happened over 2 weekends where we didn't have accommodation to offer to people over 2 weekends.
Okay. So this was a person who, this case related to somebody who was seeking readmission to direct provision but was refused, and the department lost that case. Is that correct?
Yes.
Okay. All right. Thank you. Am I right in saying as well, just in relation to emergency accommodation, and we'll move on from that in a second, that the reception regulations do allow for use of emergency accommodation However, I think it specifies that that must be for short periods of time. You've outlined that people could be there. There are some individuals. You've outlined that you try and prioritise children of school-going age to get them into direct provision centres, but that there are some applicants who are there for maybe 6 to 9 months. Like, is there a possibility, for whatever reason, that we are in breach of the reception regulations on the strength of that?
You're correct that we are entitled to use emergency accommodation for periods under the directive. I would never say that we would be in breach of any directive, because that would be a problem in Ireland, but we certainly have to work extremely hard to try and ensure that we don't have to come to rely on emergency accommodation over any sort of medium term.
Okay, well, it certainly seems to me plausible. I know that I suppose the department is never going to say that they're in breach of, I suppose, the regulation rather than directive. But it certainly seems to me possible that if there are people there for 6 to 9 months, that's not in keeping with the spirit, or I would say the letter, of the regulations. Just in relation to, a lot has been hung on to issues there in relation to improvements and all the rest of it. The first is in relation to the new standards, and you have high hopes for the new standards. I also believe that they can offer improvements, albeit that I think there's a much more fundamental and radical approach needed overall. Having said that, am I right in saying that they have yet to be published, and when will the final version be published?
We would aim, the Minister recently approved them, and we would hope to publish them imminently.
The next couple of weeks before the recess?
We're hoping to have a launch, so ideally next month.
Okay, I see. Well, I suppose that's welcome, and I look forward to seeing that. I suppose the other element is that, as I say, a lot has been hung upon, is the vulnerability assessments, and I suppose to ask, under the recast directive, so I suppose to ask the question as to where things stand with the vulnerability assessments.
Well, we believe we're meeting the requirements for vulnerability assessments, despite the challenges being posed by people, by the accommodation situation. In general, it's being met through the medical screening that takes place in Balseskin, and we are able at the moment now to put people back through the medical screening in Balseskin. Indeed, we're about to open a better medical centre in Balseskin, which will be a great improvement. And then there are other aspects of the vulnerability screening. Obviously, yes, it looks for a series of vulnerabilities. And so those are generally detected in the initial contact with RIA, or the initial contact with the system, and we're able to manage that in terms of placing people. Sometimes the vulnerabilities can come through.
Could you just elaborate on that point? I suppose the non-health related elements.
So for example, if a person presents and in part of their initial contact with RIA, they mention that they have a particular gender orientation or whatever, so that's something that we now need to take into account in terms of placing them in our centres as best we can. But it's always constant against the constant pressure of, do we have a bed for the night for them? You know what I mean? Yeah. So there is a point as well where vulnerabilities can become apparent some period into the process, and this perhaps would be particularly true, say, of things like mental health issues. And so as those are detected, often they can be detected by the management of a direct provision centre, and those are brought to the attention, if that's appropriate in terms of people's privacy, to RIA. We're able to try and manage those and put services in to support that.
Well, obviously that's appropriate, but it does sound somewhat reactive as well. Like, I mean, I suppose, are we expecting, like, I mean, do you believe that the managers of direct provision centres have the ability to necessarily evaluate and gauge?
We train, we do a lot of training for the management of direct provision centres to make sure that, for example, things like child protocols and so forth are maintained. The not reactive part of the screening is the medical screening. So that we offer that to everybody who presents looking for international protection, and a substantial proportion of people take that up. And so that's very proactive, and that's proactively offered. The other vulnerabilities and things like that, either they have to be brought to our attention by people. I mean, we can't, by looking at somebody, decide that they may have a particular vulnerability. So they have to be brought to the attention of the staff before we can appropriately assess them.
Okay. Well, I suppose, okay, I mean, you mentioned there in relation to gender orientation, but I suppose an issue has arisen recently in relation to gender identity in relation to the sad case of Silva Takula, and I suppose I've put on record my criticisms of the way that was handled. I think the coroner's office should have been notified first of all in relation to her wishes and the fact that there were people who wished to remember her with dignity. But I would also say that there was an issue, so far as I understand it, that she was accommodated in an all-male direct provision centre. So, I'm not sure how long ago that decision was taken, but obviously that's not a decision that should be taken. It seems to me contrary to what the recast directive is talking about too.
Well, first of all, thank you for the opportunity for me to be able to put on record the fact that the Department very much regrets what happened in the case of Ms Takula. In the case of her burial, wasn't at the behest of the Department of Justice. And clearly we have to change the way in which we communicate with coroners' offices to make sure that in these exceptionally rare circumstances, thankfully, that it doesn't arise again. With regard to Ms Takula's placing in centres, she was initially, as I understand it, placed in one centre and then moved to another where it was felt that where she would be placed would be more in keeping with her gender identity and would be in a better circumstance for her. So the RIA did react in terms of her initial placement, which perhaps was inappropriate, and the movement of that. But it's an incredibly sad circumstance, and we very much regret what happened in those circumstances.
Well, I welcome that, and I hope that, I suppose, in future things are handled differently, and I suppose communication with the coroner's office is key there. Just want to, I suppose, deal with, two final issues, and they're more in relation to direct provision per se. I suppose I've previously raised the case of location. Now, it's not my view that they should all be located in Dublin or anything like that. And actually, while I have the opportunity, I want to condemn in the strongest possible terms the attacks on the proposed direct provision centres in I think, Moville and Ruski. It was an appalling act, and those people, I don't think they are. Look, it's a disgraceful mindset, I think. But I suppose, while, as I said, I don't think they should all be accommodated in Dublin, there are issues with the location of some of these for the residents, first of all, I suppose. Moville would have involved people who had appointments either travelling through the 6 counties, which isn't legal, or going an extremely circuitous route to try and make appointments in Dublin. That probably wouldn't be possible in a single day, and would be, given the income I suppose the people had, would make public transport very, very challenging, accommodation, whatever. Mount Trenchard not served by public transport generally. Kenmare probably involving an overnight stay if you've any serious length of time in Dublin. So I suppose places that have poor public transport connections and require appointments in Dublin. I raised this previously with the Minister. I suppose I would be of the view that as much of that as possible, I think certainly these places have to be located where there's good public transport links, where there's opportunities to work, where there's good educational links, and the capacity exists within the community to support that centre. But in addition, I think as much as possible needs to be done to I suppose, bring the mountain to the centre, that people have the opportunity to, as many appointments and obligations as possible that can be done within that centre. So the Minister seemed open-minded. Is that being progressed?
It is, actually, and there's been some very positive developments on that front. Up to, I suppose, the end of last year, if you wish to have your interview with the IPO, you had to be brought to Dublin, in effect, and overnight in Dublin in many cases. And at the instance of the Minister, we have instituted a pilot with the IPO so that they can bring the interview process closer to the residents of the direct provision system. So an initial outing was held we have an office in Tipperary town, and that actually worked extremely successfully, save that it was in Tipperary town and it needed to be closer to our population. So we're now proposing to run those interviews in a more coordinated way in Cork in the initial phase, and actually Cork is within an hour of about 1/3 of the population of our direct provision centres. So that's a very achievable way of delivering the IPO interview process. We're also looking at delivering similar interviews in Sligo, which again would be of extremely helpful for people in the northwest particularly say, for example, for anybody we might have living in Donegal, for example. So I think that prospect of delivering services closer to the people, which of course is a standard thing for services that are delivered to Irish citizens, but has not been traditionally how we managed the interview process and the IPO system. And we're working very hard to deliver that over the course of this year. I agree with you, and in fact it has been policy for a long time to disperse people across the country so that we don't gather all, for example, asylum applicants into Dublin, for example, which would be difficult, and it would be extremely difficult in the context of the current accommodation situation. It's much better for people that they are dispersed across the country, and that as a consequence Ireland has had a great dispersal of people with permission to remain or people with refugee status have been dispersed across all communities. So every part of the country has been able to accommodate and bring people into the system. But I suppose it should say that the model that is adopted of procurement for direct provision centres, we accept any centre that is offered to us that meets our standards. So it isn't a suggestion of us choosing a particular location, it is that that's what is offered to us. I suppose part of what we would be very interested in hearing the views of the committee down the line as to whether there should be more direction as to where we locate centres and how that might be done. And that's certainly some of the considerations that we are thinking around or will be thinking around in terms of the interdepartmental group that I mentioned that I'm chairing as to the future of the way in which we procure and select sites for direct provision centres.
Okay, very well. And I'll finish on these two there. I suppose first of all, I asked a question yesterday at the last committee hearing, and I put it to the witnesses that I had a concern in relation just to the culture and attitude in relation to the Department of Justice, in relation to Inish and Ria, and I stated my view that whether it was perhaps too adversarial, and the responses I received is, one, Dr. Thornton felt that I was being generous in describing the attitude as adversarial, and that a culture of disbelief existed, that in response to a proposal from the Department of Employment Affairs and Social Protection, that it planned to provide for the increase in direct provision allowance, that an official in the Department of Justice who was asked to comment on that expressed a view stating that they are all working anyway. There was a few other examples. There was a few other comments as well that related, I suppose validly, that the Department of Justice has a responsibility for the security of the state, and perhaps that informs some of the attitude. But I didn't detect much disagreement with the view that there is an element of an adversarial attitude that exists to applicants. So I suppose it's only fair to give you the opportunity to respond to that and to give your view on that. And my final question, I suppose, is I think a lot of the discussion these last few weeks has, and it's very much in line with my own thinking, related to the potential for getting out of the private for tendering. Obviously it's not something that can be done overnight, but to go through, to seek through not-for-profit bodies, approved housing bodies, accommodation directly through the state or through community, voluntary, not-for-profit organisations, and then to integrate at the same time as that people into the mainstream system in terms of housing as quickly as possible. So, like, given how expensive direct provision has been, I think I had the statistics there, but it's 1.25 billion since 2001 has been sent on the system. Like, why has the department? Is the department open to that? Why has the department, up till now, since 2001, not pursued such an approach? Because I suppose at that time, we're talking now about this is something that we're trying to get out of in terms of emergency accommodation. This is an immediate response. But 2001 direct provision was an emergency response as well. And we're still with it, 18 years on. Thank you very much.
So just in relation to culture, as the Deputy may be aware, I've only relatively recently arrived in the Department of Justice myself, and as you know, we're undertaking a very substantial reform of the department, and I believe the Secretary-General may come in and brief the committee on that. What I would say is that I find the Department of Justice a very interesting place to work, because I've been a civil servant for a very long time, and it certainly has a different culture to any place I've worked before. But what has significantly impressed me is when I talk to the team who work on the direct provision system and the RIA team, there's very much a treatment of people as an individual human being, and that's very much what they try and achieve. Now, it's extremely difficult because of the pressures. We're under the pressures of numbers, but there is very much an attitude towards people of human beings. With regard to the international protection system, the asylum process and all that, there is a very legalistic process to go through, and people can, as with any legal process, can find that very confrontational. Because, for example, people come in, set out a series of facts, and have those challenged and tested as part of the process. But the process is very well laid out. It's very carefully monitored by the systems, very carefully monitored by the UNHCR, and it is extremely fair. And the reforms that were done in 2015, very substantial reforms to the international protection system, have led, I think, to a very big change in both timeframes and the approach to that in terms of bringing the decisions all together. So I think one example of that is that on foot of the McMahon recommendations, one of the recommendations was that people who'd been in the process for more than 5 years would have their applications reviewed, and over 1,000 people received permission to remain on foot of that review. And that was done quietly and effectively on a case-by-case basis and was delivered. So I know that people can perceive government departments, big government departments like the Department of Justice, which does have a security of the state function. It is about ensuring that the policy of immigration that the state has decided upon is deployed and enforced. But there is very much a regard for the human being in the middle of that, and but we need to keep on focusing on that. And part of the goal of the reforms of the department is to ensure that that system prevails throughout. So I can't, an individual may have sent an email. The fact is that FOI will reveal sometimes that we have robust debates in the Department of Justice, and we have them in every government department. But what I will say is, notwithstanding what may have been possibly a personal view expressed by somebody, that reform did go ahead, and we strongly support it as a department, that there has been an increase in the allowance for direct provision. We strongly support implementation of the McMahon recommendations.
Thank you, Ms Buckley. Deputy Jim O'Callaghan, please.
And thanks very much, everyone, for coming in this morning. I just have a couple of questions for you. I know the total amount we've spent since 2001, but approximately how much does the state pay each year to the providers of direct provision?
We paid 78 million last year in direct provision costs. The costs will be higher this year because there are a number of drivers. There's the emergency accommodation costs, are very expensive. Our numbers are up, and we are also, because of the procurement process to improve standards, has driven an increase in the costs that people are suggesting to us as part of the procurement process. And I don't want to obviously go into details because that is commercial. But yes, it's a substantial cost pressure within the Department of Justice budget.
And do you think we will end up paying approximately 100 million this year for it? I
think it's going to be substantially more than that.
Okay. Can I ask you, in terms of each direct provision provider, they obviously enter into a contract with the Department of Justice. Are those contracts publicly available?
We make the details available 2 years, a 2-year delayed process in order to protect the commercial sensitivity of those contracts.
Okay. And obviously I'm not trying to get into the commercial sensitivity, but if we're paying the same, are we paying the same rate per person to each direct provision provider?
No, because some of the providers provide different facilities. Some people are providing facilities in state-owned buildings and so on and so forth. So there's a different range of facilities being provided, as well as these contracts being provided to individual operatives. So we negotiate with them.
Yeah. And presumably each contract with the direct provision provider will set out a series of terms and conditions that they have to comply with in terms of the service they provide. How does the state assess whether or not those terms and conditions are being complied with by the providers?
So we take into account, first of all, we inspect each centre 3 times a year, twice by RIA staff, that's the goal at least, twice by RIA staff and one by an independent inspection company that we contract to do so. We also obviously take into account things like complaints from residents, our direct interaction with the management of centres and so on and so forth, and we have a lot of interaction across the system all the time.
Okay. Can I ask you, are the inspections announced or unannounced?
Unannounced.
Okay. Some of the recommendations we've received is that there should be a HICWA-style inspection of direct provision centres. What do you say in respect to that?
Well, we haven't determined what entity should do the inspections. It's certainly part of the introduction of the new standards, which will be coming into force on the 1st of January 2021, that there would be a different inspection regime for that. Yeah. Whether that's HICWA or another entity, it hasn't been determined as yet.
Another method by which you get information as to whether or not the conditions are being complied with is through engagement with residents. Is there any formal method by which you engage with residents, or are you dependent upon them coming to you and informing you of complaints they have?
We aim to hold clinics on a quarterly basis where residents can come and make any issues that they have. Now, it has been quite pressurised for the staff to manage that, but it's certainly the goal to go down and have meet with residents every 3 months and make sure that their views are heard. In any instance where something arises and there, like there have been a couple of protests and things like that, we tend to send a staff member down that day or the following day to see what the story is and to make sure that we're on top of whatever has occasioned that issue. So but we do proactively go out and seek the views of residents. We also, of course, have the Ombudsman's office and work quite closely now with the Ombudsman, and they go out and visit every centre every year, listen to the complaints of residents, and many of them, as you'll have seen from the Ombudsman's reports, tend to be about local communication issues that can be resolved on the spot.
Do you find that residents are hesitant about communicating complaints or concerns they have about the providers?
Some residents not at all. They would be not behind the door when it comes to complaining. They're like all human beings. Some people complain more than others, I suppose. But no, I think we tend to find out very quickly when something has happened. If for no other reason than people are on social media, people have their phones and they've got Wi-Fi in the centres, and they complain about stuff. Mm-hmm. And our biggest challenge is reacting quickly enough that we can deal with the situation fast and make sure that it's sorted out for people.
Mm-hmm. And when a complaint is made and you respond to it, what authority or what control do you have over the service provider to ensure that the appropriate changes are made?
It is very much a part of their contractual requirement that they meet our standards. So just to give you a specific example, and I think the lady in question came and gave evidence to the committee where, contrary to our standards and our rules for each direct provision centre, she had a sick child but was refused food at a kind of a late hour. And that was once that was brought to our attention, which was very quickly through social media. We then spoke to the accommodation provider. It related to an internal communication with a staff member and was dealt with very, very quickly. The accommodation providers tend to react when they get a phone call from RIA very swiftly, because they know that if a store of complaints are built up, well, that's going to be a problem for them when it comes to their contractual arrangements with us.
Would you agree that this state is going to have to continue to provide what we refer to as direct provision services for probably the next 20, 30 years or the foreseeable future?
Whatever we call it, and
yeah.
I know direct provision, and your colleague mentioned that it has lost the faith, and certainly that's the feedback I get from my own friends and family. But what I was really struck by in reading the submissions that you got from the NGOs that presented before the committee is that all of them agree, really, that accommodation has to be provided for a period and state services have to be offered at least for a period, right? So whatever we call it, whether we call it direct provision or something else. Yeah. So I don't...
Who came up with the name, by the way?
Oh, I don't know, it's 20 years ago, and the concept of providing state services directly to residents, is not, I suppose, a bad one. Perhaps, though, what needed to have been done at an earlier stage is the process we're now going through, which is to bring in somebody like Brian McMahon, an independent person who could say, look, the standards just aren't good enough, and to set a new set of standards that we have to meet. And that's where we're at now. Would
the state ever consider building its own centres that it would use as direct provision centres indefinitely into the future?
Certainly, we are open to any recommendations that the committee may come up with, and that we're going to look at all available options. It's probably likely that a mixture of accommodation types is the right way to go. Some of the centres that we have at the moment, 7 of them, are on state property, but are run privately on behalf of the department. And we would very much welcome more involvement by NGOs in the process. So we are talking to some of them about seeing whether, particularly for some of our more vulnerable people, whether NGOs would be able to provide some of that accommodation.
Okay. When you're determining whether or not to grant a contract to a direct provision provider, do you take into account the remoteness of the location, and do you rule out particular locations because they're too remote for potential residents?
It's an obligation on a direct provision provider to provide transportation if public transport links aren't available. We haven't been in a position to rule out appropriate accommodation on the grounds of remoteness in the last little while, because we need to expand our numbers of beds. But we do have standards around making sure that there is available connections to bring people into local communities.
Is the department aware that, I suppose, one of the big complaints of residents in the centres, in certain centres, is boredom and a lack of capacity to engage in ordinary life that would be done by people who are fully integrated into society?
We're fully aware that that is a complaint, and we are working very hard to try and alleviate some of that, both through the standards that will be brought in, which will require better facilities on site, through the requirement to introduce connectivity, and also through setting up things like Friends of the Centre, so you integrate people more directly with local communities and local NGOs, and that's been quite a successful endeavour for each of the direct provision centres.
Mm-hmm. Obviously there's an issue in respect of people who've been granted protection and yet they don't want to leave the direct provision centre. How is that an issue that you think we should respond to?
It's a very big problem for us. We are working very hard, and how we have responded to it is, first of all, we have set up relationships with a number of NGOs and charities, and we have reached out and reached an MOU with the CCMA, with the City and County Managers Association, to provide their services, for example, HAP services, to people who have the right to remain, permission to remain, and need to move into mainstream housing. In the last 2 weeks, we have started to write to the residents of various centres, and would include Mosney, for example, to tell them what those services are and to invite them to engage with those services so that we can start to help people move more actively out. I should say this is a problem only of the last 1.5 to 2 years. Prior to that, people got their right to remain and tended to move on quite quickly. So the requirement to help people move on has only been an issue for the last, I'd say, 18 months or so.
Do you think it's a consequence of the housing crisis in the country, or is it related to something else?
It's partly the housing crisis, and maybe also it's partly that we haven't been active enough in engaging with people to get them to move.
Haven't been active enough?
We haven't been active enough, and now we're moving into a more active phase.
Do you think the state needs to be more insistent about people having to leave once they have their protection positions clarified?
We certainly will need to set expectations around people moving on. We, of course, don't want to be accused of making anyone homeless.
Of course.
But we do have situations where people who have every right to remain in the country, for example, we have a situation where some programme refugees have been brought in, have been situated in one of our direct provision centres, or EROC centres, have been offered other types of accommodation but have refused them and want to remain in the centre. So we're going to have to, I think, start to make greater efforts to insist that people accept the alternative accommodation that they're offered, and they cannot remain within our centres because we're under too much pressure.
Okay, thanks very much, by the way.
Thank you, Deputy.
Chairman.
Very much, Deputy O'Callaghan. Now, Deputy Martin Kenny, and then I have a few points to share with you as well myself, and then we'll come to a conclusion. Deputy Kenny, please.
Thank you very much, Chairman, and thank you for the opportunity. I'm not a member of the committee, but I have, I suppose, a long establishment in Ballinamore in County Leitrim. There was a direct provision centre there for many, many years, and I knew many of the residents in it. And I do often say that, you know, I don't think any of them even as much as broke a window around the town for the time they were there. They were really well integrated into the community. Now, there were issues with the facility, and that was, eventually it was closed down a number of years ago. But in recent times, we have, and in fact it's quite apt because this weekend a number of residents came from, I think from Dublin, most of them, to an emergency accommodation in Caoimhghín Channel, which was opened up. And there was a little bit of I suppose, somewhat people in the community that were somewhat aggrieved that there was no prior notice or that they didn't know in advance that these people were coming. And that's been explained. I've learned quite a bit from the listening to the interactions so far, and has been explained that in most cases the people who are going into emergency accommodation, that you try not to move families into it because it's short term, and that meant that it was all men that arrived in this particular centre, and I think it's going to be the same going into the future. I suppose some of the issues that I'd like to get clarity on, I went in the other day and I met some of the people who were there, and I understand that some of them may be doing courses, may be involved in education from where they had been before. Now, of course, colleges are closed, education facilities over the summer, but most of them will want to, any of them that are doing that will want to go back to that later on, and I'd just like to know how will that be worked out in the situation where they're now in an emergency accommodation, maybe 100 miles or more from where they had been in receiving their education, or similarly if they had been in work, as some of them who are here more than 9 months are entitled to seek a job and often are in employment, and that can be a difficulty. Now, having said that, Caoimhghín Shannon is a tourist town and it's a very welcoming place, and you know, in general, I'm sure if they were looking for employment that was suitable, they could find some possibly, but there is that issue there in regard to that. But particularly I'd like you to maybe explain why in situations like this that there is that level of secrecy or whatever, because that raises suspicions with people, which I think are unnecessary, and I'd just like to, maybe if you could explain that.
Thank you. Well, if I can distinguish between emergency accommodation and direct provision centres. So first of all, as you know, we've had many complaints about actual direct provision centres being opened and people not being informed, and it's landed into communities. And we know we need to get better at communicating around that, and we are working very hard whenever a direct provision centre opens that we will once we've completed the contractual negotiations, and obviously there's a bit where we are engaged, and indeed even in the short time I've been in the department, there have been a number of instances where we've opened negotiations, but an actual direct provision centre hasn't resulted from it. So there would be absolutely no point in talking to people. But we know we need then to communicate that with the local authorities who might have interests from fire safety or whatever, the local councillors will, of course. And then, of course, we need to engage with the local community who often have concerns that can be allayed relatively swiftly around kind of the nature of people coming, but then would have concerns around things like GP services, schools and so on and so forth. And those are the things we know we need to get better at. Emergency accommodation is different because, of course, we're scrambling around to find places to put people. The particular group of people you're talking about, they had to be moved out of Dublin because one of our centres in Dublin is closing. Oh, yeah. So, I mean, Carrick is a great option for them because, as you say, it is a tourist town, and therefore the opportunity to work should be reasonably readily available and so forth. We continue to have an ongoing difficulty about people who are in education, particularly people who are offered third-level education, for example. So that we have a number of universities who are working very hard to offer free educational facilities, but those free educational facilities don't come with accommodation. And so it rebounds upon the Department of Justice to somebody's accepted for a university degree in Trinity or DCU or whatever, and then we're asked, well, you need to accommodate them in Dublin, and we actually don't have an awful lot of accommodation in Dublin anymore. So that is an ongoing challenge for us. I don't deny that, and I don't have any specific answer, but perhaps Carol?
Just to say that in that context, we have been in contact with the universities to see if they could support students with university accommodation, that there could be a shared programme as part of their Universities of Sanctuary programme. So we're hopeful that we may be able to get some progress there.
And also in regard to individuals that may have, perhaps they may have a social worker perhaps working with them, because many of them come while you know, their lives may have been traumatic in the past and all of that, and when they move a long journey away, how does that fit in, or will services locally have to step in, or where, because that in many cases, as you know, those services are very, very hard to find for the people, the local residents, and that's their issues as well that people are concerned about.
Once again, yes, I mean, once we move people, whether that's within the direct provision system or into emergency accommodation, the challenge is making sure that the services are available to them locally, and that's particularly difficult with the emergency accommodation, because it has been something that we're just setting up and establishing as we go along. So it's something that, if there's anything specific that you want to raise with us, Deputy, about the people in Carrick, we can certainly work with our colleagues in DEASP to make sure that we address the problems or whatever issues arising. Without obviously want to go into the details, it's something that we ourselves are very challenged by, to try and deliver that.
And just in regard to the issue of that little bit of secrecy or people not knowing in advance, is an element of that around issues of fear that if it's put out there into the public that you would have issues like what happened in Ruski or things like that? Is there a fear of that as being as part of this reason, or is it just purely commercial sensitivities?
It's really purely commercial sensitivities, to be honest. Thankfully, what happened in Moville and Ruski is extremely rare. And generally speaking, what happens is that, and this is true of direct provision centres, and you probably are aware of this yourself, is that there is an initial pushback, but once the centre opens and all that, it all dies away, because people know, as you quite rightly point out, there isn't a day's trouble from the vast majority of people. I mean, when I went and visited Mosney, I asked, was there much trouble, and the people who run Mosney told me they had more trouble on a bank holiday weekend when they were run as a holiday centre on a single bank holiday weekend than they have in the whole time they've been a direct provision centre. So we also have to manage the privacy of the people involved, and so part of the problem is, and rumours go around, you know, you're putting people in, you're opening a direct provision centre, blah blah blah, and we struggle to respond to that because it's our obligation to keep the privacy of the people involved very under wraps. So we often have to respond to media queries and queries from interested individuals by saying we can't actually give them the information they're looking for, which is just part of running systems where we've got to preserve the privacy of people in the international protection process.
Also, in regard to the actual emergency provisions themselves and the buildings, in this particular case, it used to be a bed and breakfast, it's an entire building, and in some cases it's just rooms in a hotel or whatever. In regard to that, is the contract a contract short-term, or is it a long-term contract when you're in that situation? Because the reason I ask that is, it was said earlier that one individual or more was more than 9 months or up on 9 months in the same emergency provision. We understand that these contracts are quite short-term, 3 to 4 months, but are they simply automatically renewed and the same people end up staying on, or is there going to be some protocol around that? And the other issue in regard to that is that if it's emergency provision, and this is a fear that people have raised as well, is can additional accommodation be added on? For instance, there's a big yard at the back of a building. The next thing is we find a whole lot of porta cabins arriving into it or something. Or is that out of the question?
We essentially contract for approximately 6 months, but we can have shorter arrangements, and we're reviewing them on a month-by-month basis. But they're actually for a set number of rooms and a set number of people. So no, we wouldn't envisage that for instance, a centre would then have lots of porta cabins. In fact, because the agreement is for a stipulated number of people.
And they always have the fire certificates and their safety procedures and all that is checked in advance. Finally, it's just, I suppose, maybe, I don't know whether any research has ever gone into it, on the other side of the justice sector, people who are either asylum seekers or people who have got asylum and have stayed on in the country, have we got any idea as to what percentage of those have been actually come into contact with the criminal justice system from a negative point of view, either during the time they were seeking asylum or after they received asylum? Or has there any research done on that? I imagine it's very tiny, and that's why I asked the question.
Sorry, excuse me. Yes, Debbie, there hasn't been any formal research done. We would have regular contact with our Garda National Immigration colleagues across the whole immigration sphere, and they will occasionally bring us to attention individual cases of criminality. I would have to say the number of cases that have come through the refugee process that have subsequently come to attention are quite low. Almost single figures, I would say, per year. So there isn't a criminality issue that we would be aware of that would be any different than the population in general in society.
Very much. Thank you, Chairman, again. For
Kenny, thank you. And just to thank the panel for their responses to the various questions. Just a number of little things that occur. Ms. Buckley, I think on at least 3 occasions you referenced one direct provision centre by name. And we understand why. While it has its issues, Mosdy is by far and away the best representation of the current direct provision system. It's not representative of what is out there. It just isn't, and that's part of the problem that we see. I think we would have an even greater problem, if not even a crisis, only but for some of the decisions that have been taken that have significantly relieved the stress within the system. I speak, for instance, of the increase in the weekly stipend. That has helped. But the much more important decision was the right to access work, to afford people the dignity and self-worth of work. And I'm saying that because I know from my own community and knowledge of the situation, it has made an enormous difference, underscoring the fact that these are people, human beings just like ourselves, and the right to face a day's work and to come home in the evening, be you a single individual or even, perhaps even arguably more important if you have a family, as many of them do. So these are important decisions. I would think that the current arrangement post 9 months, that could be looked at. I think it would be important to bring that back considerably. Doesn't in any way impede the processing. And the processing issue is a big issue. And very little of even your opening statement and the focus of the questions in relation to what can be done. I do understand and appreciate the complexities, the legal elements within the appeals system, et al. All of that builds up. But, you know, how do we compare in terms of international comparators? I don't know is my honest answer to it. But I think we need to most certainly explore the processing of applications with a mind to reaching real and fair decisions at the earliest possible time. I think that that's absolutely essential. I'm going to make a couple of points, and I just invite you to come back in any general way at the end. It strikes me you're the Department of Justice and Equality. And there's this ever-present reality presenting here today that you're now, like it or not, almost a housing authority. You have a cohort of people to provide housing for. You're speaking of people who You know, in the health services, people holding up beds have been wrongly described. Here we're looking at you have people holding up beds within the direct provision system that might equate with the number in emergency accommodation if you were able to secure them housing accommodation within the wider society. Are there steps being taken to explore what some of the colleagues have raised, i.e. in terms of engagement with housing associations? I would echo some of the views of my colleague members in relation to, you know, looking seriously at the provision of, you know, temporary housing provision, the construction of temporary housing provision. What stands out about Mosney as against some of these older buildings, be they whatever, in past use? Many of them are just not suitable for what they're currently undertaking. Mosney is quite unique because of its construct, the thought behind it. Is there the prospect of replicating clusters of such? I mean, the standard of it, if it is to be temporary, direct provision, you know, the greater number of us in any conversation, we would think that 6 months is more than adequate in terms of the processing, procedure, accommodation, and, you know, if there were housing provision of, you know, that standard that allowed people to cater to their own needs, allowed them to cook the food that they're used to purchase, access through local stores, and to be able to perform and operate as a family in many of the instances that they are families. So, I mean, the concentration of effort on searching out and identifying maybe former hotel properties and all of this, you know, that's finite. There just isn't an endless supply of these any more than there's an endless supply of former agricultural colleges in my own backyard. So I think we need to be looking much more seriously, because the numbers that we'll present, it's not going to end tomorrow or next year. The situations that have given rise to the growth in numbers are conflict situations that are continuing. People are genuinely, in the greater number of cases, fleeing very fearful situations. So we need to step up to the plate in a real and serious way. And I think that a serious exploration of that housing provision is the only way that we're going to move away from. And I welcome the fact that you've said emergency accommodation, we want to get out of it. Well, I absolutely welcome that statement here today, but, you know, we need to look seriously. We cannot be hoping and praying that the numbers will drop and, you know, we'll cope better then. It's not going to happen that way, and we need to be looking at new and imaginative ways of dealing with. And again, I underscore once more, the more speedier processing, that needs to be seriously examined. And I would welcome any comment that you might have to make on that before we conclude. Could I just say that independent catering and the purchasing of food for meal preparation, that's such an important need for people, such an important need, and it's not universally the case. You know, it's sad to meet with young school-going boys and girls, and as I have in the very recent past said to them, knowing their school uniform, you're getting your holidays, you're looking forward to the holidays. And I can honestly say to you, not one in the little group that I spoke with were looking forward to the holidays. For them, the great joy was getting to school every day rather than being in what they viewed as an isolated, limited scope location. School enthused, it gave them all sorts of opportunities and mixing with the school population. From the very first day of the school summer break, they're looking forward to getting back to school in September. Now, that's unique. I guarantee you that wasn't my children's story, nor any of their neighbours. So we need to be very, very cognizant of that. You spoke about health screening in advance of placement. And I know that while RIA hasn't a direct responsibility in terms of health and education provision, nevertheless it does state in its outline of responsibilities working with the other services to ensure. So health screening in advance of placement, but what of health issues presenting subsequently? I mean, I know of situations, not only in my own immediate backyard, but elsewhere, where accessing a GP is now almost an impossible project. You spoke of chickenpox. Can I just say that on Monday of this week, and I would ask, perhaps Mr. Sinclair would take a note of this, I wrote to RIA on Monday of this week, and I just addressed it without a named official, instancing, and I believe it to be the case of an unaccompanied child within the direct provision system who is not accessing education and who in the course of the year so far has had chickenpox and could only access calamine lotion because had no access to a GP, and because the young person is relatively tall for their age, sometimes can be viewed as perhaps a young adult, which they're not. I've seen the birth certificate and I can confirm that they are not, and they're unaccompanied, and they are in great distress. So I've documented all of that this week, and I would appreciate address of that particular case that I've highlighted. I think it is absolutely imperative that that child and their needs are catered to. And I want to support the views expressed by Deputies Chambers and O'Callahan and others as to the importance of an independent audit of the accommodation centres and of the needs of residents. And it isn't only a case of presenting, you know, you may say that those who are inclined to crib and cry will be the ones who will be heard first. Well, that's not an un-Irish thing itself. But the fact of the matter is there is an element of fear, distrust among the population in these centres. They're mindful that they're applicants for asylum. They are loath to give voice to matters. Some of them can be quite simple and easily resolved, but they're fearful. And that fear factor needs to be taken on board. So the people who would engage, those who would be entrusted to do an independent audit as against a RIA visit, be it announced or unannounced, they need to have the people skills and the necessary understanding of the people that they're meeting and dealing with. That is hugely important if the truth is to be got to. The truth is hugely important. I've covered several matters in that little outline. I can say as a host community, not only of direct provision, but of emergency accommodation, people are horrified at the emergency accommodation approach. And I'm speaking about people in my home county of Monaghan. Horrified that such an approach has been employed, and we are very, very cognizant of the references to moving people at very little notice to accommodate other events. It offers no understanding whatsoever of people's dignity and their particular needs. So there is great offence, I can say, among, I believe, the overwhelming number of the population of my home county at that. And there is a very strong view that we need to do much better than we are currently in relation to direct provision. And some of these issues I have reflected to you, and I just invite you to make whatever closing response you would like.
Thank you. So in relation to Mosney is the goal for the system. So if we are to introduce the new standards, we will be moving to a better form of accommodation offer across the board. I agree with you that particular centre is certainly the jewel in our crown at the moment, but if it offers the model of where we need to try and get to around independent living and so forth, and that's something that we are working very hard to try and achieve. With regard to international comparators, it's very hard to compare internationally Ireland's processing system to others because we have a different legal system, we have a different structure around taking decisions, and we treat international protection applicants entirely differently to some other European countries. For example, some other European countries detain applicants for asylum. We don't detain anybody. We are working very hard to achieve the 9-month median goal. I won't be thanked by my colleague to my right if I were to try and set a more challenging goal for him and his team. What I would say is that, as you know, I come from a processing, I was the head of the WRC, and there actually is a limit on how short you can get a process down to. Because you have to give people the opportunity to return questionnaires and things like that. So there is an absolute minimum period that we can get things down to. And Michael and his team have been working very hard on introducing a shortened time frame for applications for some of these safe countries that we've referenced, Albania and Georgia, in conjunction with the UNHCR, that will tighten the time frames around that in a way that remains fair to the applicants, because we still have to give individual consideration to their application. With regard to health screening and health access after screening, I suppose what's unusual in the system is that there is that health screening offered to everybody. After people are in the process, they have the same right to access health services as ordinary members of the Irish population. And you've identified an issue there. So that's something we try to work very closely with our colleagues in the HSE to make sure that, and particularly where a direct provision centre is opening in an area, that we allay the concerns of the local population that there will be yet another demand placed on local GP services and things like that. But that is a challenge. There's no doubt that offering health services in any part of the country is a challenge. A child should not be in direct provision. And if you have brought a child to our attention, we will be referring that person into the TUSLA services. Children are referred to TUSLA. With regard to independent audit,
strange.
I'm surprised.
That to your attention.
Yeah, I'm surprised, but thank you for doing that, and we will take that on board and examine the situation. On the independent audit, we certainly know that when the standards are introduced, one of the important parts of that will be how we measure up against those standards. But I just want to mention around the fear factor, first of all, to put it on the record, that nothing that happens in a direct provision centre, no complaint that's made or whatever, can have any impact whatsoever on the decision process of the IPO or the IPAT, because those are independent in the operation of their functions. There is a Chinese wall between the systems. And I appreciate that there may be fear, but maybe it's as well just to say bluntly out loud now, somebody who complains within a centre about some circumstance within the centre, it will have absolutely no impact whatsoever on the legal consideration given to their application for asylum or for protected status under any circumstances. And actually what's really good about, perhaps now is, as well as being able to complain to RIA about any circumstances, obviously the right now of access to the Ombudsman and the Children's Ombudsman. So we have that system now whereby people can complain to somebody who's completely independent of the system entirely and have their complaints addressed just as an Irish person can. I think that probably covers many of the things, but just to say that we will be very interested in hearing any recommendations that the committee may wish to present. We cannot promise that we will be able to change course on this as rapidly as other people might like, but we are moving, we know, towards a better system. But we will take on board and give consideration to any recommendations the committee may have. And just to reiterate, we are really open to other models of provision of these centres. We are not fixed on one form of provision. However, we'll probably have to have a bit of a row with our colleagues in the Department of Public Expenditure Reform if we wanted to change our budgetary situation, but sure, so be it if that arises.
If we could help in that regard, we certainly would.
Well, we welcome any help you can give us.
Well, with that, I'd like to, on behalf of the committee, and we had a good participation here today, I want to record my thanks to Una Buckley, to Carol Baxter, to Michael Curran, and to Paul Gunning, and also to Louise Sandham and George Sinclair for attending here this morning. This concludes our series of hearings. We have of the order of 140 written submissions. We've had the opportunity on Friday to visit direct provision, and we will be over the summer period preparing our report for publication in the early autumn resumption post the summer recess. So on behalf of the committee, I again thank each of our witnesses for your attendance and for your participation here today. The Joint Committee is adjourned until 6:15 on Wednesday the 26th of June, that's this day week, and I just want to remind deputies that we're going into Select Committee at 12 o'clock. Thank you very much indeed.